Good day everyone, good day ma'am. I'm Elaiza Taculod from BS Edition 3B, and right I'm going to report the chapter 12 entitled Laws Related to Tourism Investments and Finance. So we have here the learning objectives. First is to enumerate the procedure in setting up a tourism-oriented business, explain the laws governing tourism investments and financing tourism-oriented projects, discuss the business models applicable to tourism projects, enumerate the various taxes application to tourism-related establishments, and lastly discuss the limitation of foreigners in tourism investments. It has been the policy of the state to recognize the indispensable role of the private sector, like the tourism industry, and provide incentives for its needed investments. And this chapter deals with laws related to promotion, monitoring, and regulation of tourism investments and finance in the country. Basically, this will tackle the participation of foreign investors as well as incentives given to Filipinos in case they will invest in the tourism industry. Special laws are even created to address needs of certain sectors like the informal sector, Filipino balikbayans, retirees, and senior citizens. First, we have here the Foreign Investments Act of 1991. The term Philippine national shall mean a citizen of the Philippines or a domestic partnership or association wholly owned by citizens of the Philippines or a corporation organized under the laws of the Philippines, of which at least 60% of the capital stock outstanding and entitled to vote is owned and held by citizens of the Philippines, or a corporation organized abroad and registered as doing business in the Philippines under the Corporation Code, of which 100% of the capital stock outstanding and entitled to vote are wholly owned Filipinos, or a trustee of funds for pension or other employee retirement or separation benefits where the trustee is a Filipino national, and at least 60% of the fund will accrue to the benefit of Philippine nationals. So small and medium-sized domestic market enterprises with paid in equity capitals equivalent of 200,000 US dollars are reserved to Philippine nationals, provided that if they involve advanced technology as determined by the Department of Science and Technology, or they employ at least 50 direct employees, then a minimum paid-in capital of $100,000 shall be allowed to non-Philippine nationals. The phrase doing business shall include soliciting orders, service contracts, opening offices, whether called liaison offices or branches, appointing representatives or distributor domiciled in the Philippines or who in any calendar year stay in the country for a period of periods totaling 180 days or more, participating in the management, supervision, or control of any domestic business firm, entity, or corporation in the Philippines, and any other acts that imply a continuity of commercial dealings or arrangements and contemplate to the extent to the performance of acts or works or the exercise of some of the functions normally incident to prosecution prosecution of commercial gain or the purpose and object of the business organization. However, that the place doing business shall be deemed to include mere investments as a shareholder by a foreign industry and domestic corporations that registered to do business and or exercise a right as such investor, nor having a nominee director or officer to represent its interests in such corporation, nor appointing a representative or distributor domiciled in the Philippines which transacts business in its own name and for its own account. Okay, so we have here the discussion of the law. Republic Act 7042 as amended by Republic Act 8179, March 25, 1996, also known as the Foreign Investments Act of 1991, provides for the policy that foreigners cannot invest in all activities and enterprises in the Philippines except those covered in the negative list. When a foreign investment in the Philippines is not covered or does not seek incentives under the Omnibus Investment Code, the foreign national or entity can ascertain the extent of allowable foreign equity in the enterprise sought to be entered into by simply referring to the negative list and filing the necessary requirements with the Securities and Exchange Commissions. Under also the Foreign Investment Act of 1991, FIA 1991, a foreign national or equity must determine the kind of enterprise sought to be entered into, whether the enterprise is a domestic market enterprise or an export enterprise. So what is the domestic market enterprise? It shall mean an enterprise which produces goods for sale or renders service to the domestic market entirely, or if exporting a portion of its output continually fails to export at least 60% thereof. In domestic market enterprise, foreigners can invest as much as 100% equity except in areas included in a negative list in case the paid in equity capital is less than the equivalent of $200,000, and such domestic market enterprises is reserved to the Philippine nationals provided that 1. They involve a technology as determined by the Department of Science and Technology, and also they employ at least 50 direct employees, then a minimum paid-in capital of 100,000 US dollars that shall be allowed to non-Filipino nationals. So if the activity is in the negative list, foreign ownership in the enterprise is generally limited to a maximum of 40% unless the Constitution or other laws provided lower limit. Next, we have here the export enterprise. It shall mean an enterprise wherein a manufacturer, processor, or service including tourism enterprise export 60% 60 export export 60% or more of its output, or wherein a trader purchases product domestically and exports 60% or more of such purchases, and these are no restrictions on the extent of foreign ownerships after 100% in export enterprises, unless the products and services fall within the negative list A and B or utilize raw materials from depleting natural resources. Okay, so we have here the procedure for registration. A foreign national or entity not seeking to avail of incentives under the Omnibus Investment Code shall file an application of registrations as follows. First is the corporation and partnership with the Securities and Exchange Commission, SEC. The existing requirements for foreign corporations are name verification slip, certified copy of board resolution authorizing the establishment of a Philippine office designating the resident agent, and a stipulation that in the absence of such agent or upon cessation of its business in the Philippines, and the SEC shall receive summons and legal processes, financial statements as certified by independent certified public accountant of the home country for the immediately preceding year at the time of the filing of the application, and also the existing requirements in case of new domestic corporation or a partnership, articles of incorporation or partnership, name verification slip, bank certificate of deposit, special investors, resident visa of the alien subscribers, and proof of inward remittance for non-resident aliens. Next, as we have here the single or sole proprietorships with the Bureau of Trade Regulation and Consumer Protection (BTRCP) of the Department of Trade and Industry, aside from the registration requirements as mandated above. Section 125 of the Corporation Codes requires foreign corporations wishing to do business in the Philippines to secure license from the SEC, allowing foreign corporations to do business in the Philippines. Moving forward, we have here also the investment in transportation, business, and public utilities. Article 12, National Economy and Patrimony, Section 11, no franchise certificate or any other form of authorization for the operation of public utility shall be granted except to citizens of the Philippines or the corporations or associations organized under the laws of the Philippines, or at least 60% of host capital is owned by such citizens, nor shall such franchise certificate or authorization to be exclusive in character or for a longer period than 50 years, neither shall any such franchise or right to be granted except under the condition that it shall be subject to amendment, alteration, or repeal by the Congress when the common good so requires. The state shall encourage equity to participation in public utilities by the general public, and the participation of foreign investors in the governing body of any public utilities enterprises shall be limited to proportionate share in its capital, and all the executive and managing officers of such corporation or association must be citizens of the Philippines. Next, we have here the investment and travel agencies and tour operators. The following may apply for accreditation as tour operator: a resident Filipino citizen, a partnership organized the laws of the Philippines, at least 60% of its capital being owned by Filipino citizens, and the corporations organized under the laws of the Philippines, at least 60% of the subscribed common or voting shares of stock of which is owned by Filipino citizens, and the composition of its board of directors being at least 60% Filipinos. The above provides the limitation of foreign participation to 40% for purposes of accreditation and operation of the travel agency and tour operator by the Department of Tourism. In addition, Memorandum Order Number 211 approving the 2006 Investment Priorities Plan, April 4, 2006, tourism, which cover travel agencies or tour operators, has been classified as preferred activities pursuant to Article 29 of the Omnibus Investment Code of 1987. Thus, in order for a travel agency, a tour operator to be entitled for registration under the Investment Priorities Plan, an applicant must satisfy the Board of Investments that he is a citizen of the Philippines, and in case the applicant is a natural person, or in case of a partnership or any other association, it's organized under Philippine laws, and at least 60% of its capital owned and controlled by citizens of the Philippines. The applicant is proposing to engage in a preferred project listed or authorized in the current investment policies priorities plan within a reasonable time to be fixed with the board, and the applicant is capable of operating on a sound and efficient basis of contributing to the national development of the preferred area in particular and of national economy in general. Moving forward, we have here the investment in hotels, resorts, and other accommodation establishments. By reason of the enactment of Memorandum Order Number 211 approving the 2006 Investment Priorities Plan, April 4, 2006, tourism has been classified as preferred activities pursuant to Article 29 of the Omnibus Investment Code of 1987. Tourism covers the development of tourism economic zones, tourist states, eco-agritourism facilities, and establishment tourist accommodation facilities like hotels, resorts, and other tourism accommodation facilities such as apartheid, pigeon houses, tourist inns, and similar establishments. Thus, in order for tourist accommodation facilities to be entitled for registration under the Investment Priorities Plan, an applicant must satisfy the Board of Investment that he is a citizen of Philippines, the case capital of applicant is natural person, and the applicant is proposing to engage in preferred object listed or authorized, and the applicant is applicable, and the applicant is capable of operating on sound and efficient basis of contributing to the national development of the preferred area in particular and of national economy in general. Next, we have here the tourism projects under the Build, Operate, and Transfer BOT program. Republic Act Number 6987, as amended by Republic Act 7718, referred to as the BOT Law, implements the declared policy to the state to recognize the indispensable role of the private sector as the main engine for national growth and development, and provide the most appropriate favorable incentives to mobilize the private resource of the purpose. The coverage of the BOT law extended not merely to government infrastructure projects, but also to government development projects. The following are the schemes recognized under the law. Any individual partnership, corporation, or firm, whether local or foreign, including joint venture or consortia of local, foreign, or local and foreign firms subject to the limits herein set, may participate or apply for pre-qualification projects covered under the provisions of the Act. We have here also the foreign exchange regulations under Central Bank Circular Number 1353, September 21, 1992. The Monetary Board further liberalized the foreign exchange regulations on receipt and disbursement of resident arising from non-trade and trade transactions. As a general rule, foreign exchange may be freely sold and purchased outside the banking system. Foreign exchange receipts, acquisitions, or earnings may also be deposited in foreign currency accounts, whether in the Philippines or abroad, or brought out of the Philippines. Moving forward is we have here the franchising. A franchise is a privilege given to a dealer by a franchise service organization to sell the franchisor products or services including trademarks and trade names in a given area with or without exclusivity, and such arrangements are sometimes formalized in a franchising agreement, which is contract between a franchisor and a franchisee, wherein the former may offer consultation, promotional assistance, financing, and other benefits, and the franchisee must pay a franchise fee for a such right. In addition, the franchisee is typically required to use the franchisor's product. Under Republic Act Number 8293, also known as the Intellectual Property Code of the Philippines, the term intellectual property rights consists copyright and related rights, trademarks and service marks, geographical indications, industrial designs, patents, layout designs, topographies of integrated circuits, and protection of undisclosed information. The Intellectual Property Code mandates that all technology transfer arrangements must comply with the voluntary licensing of all intellectual properties in order to prevent or control practices and conditions that may constitute an abuse of intellectual property rights, having an adverse effect on competition and trade. To implement taxes on all payments relating to technology transfer arrangements shall be borne by the licensor. We have here also the Barangay Microbusiness Enterprise. It is Act of 2002, RA 9178, July 22, 2002, was enacted to hasten the country's economic development by encouraging the formation and growth of barangay microbusiness enterprises, which effectively serve as seedbeds of Filipino entrepreneurial talents and integrating those in informal sector with the mainstream economy through the rationalization of bureaucratic restrictions, the active intervention of the government, especially in the local level, and the granting of incentives and benefits to generate much needed employment and elevate poverty. And that's the end of my report. Thank you and have a good day.